Hello, hello, hello. How is everybody? Happy Tuesday evening. I hope everybody's day went well. We had a busy morning this morning. We had the whole hearing, and it was like a surprise that it was live streamed because nobody ever has carried it before live like that. It's usually uploaded after the fact, and wow. All right, so we have a lot to go over tonight. All right, so on the agenda for tonight, first things first, if you haven't already done so, give your girl a thumbs up or a thumbs down on the stream, whichever you prefer. Either way, it's all good. That's number one. All right, number two, how we're going to do this tonight, just so you guys know, is we're going to watch a little bit of the hearing that happened today. We're going to hear from the attorney who gave an interview afterwards. We're going to talk about George's brother. We're going to talk about the motions that were filed that were filed today in court. They're now up on the Orange County Clerk website. We're also going to talk about the two experts that the defense wants to hire. Also, when we talk about the defense experts, I happen to have the professional visitation logs, which is any attorney visits, like her PI, anybody that's part of her legal team that visited her. And we're going to check those out. So that is what is on the agenda for tonight. So it's probably going to be a long one because I got to present the stuff. And as I'm presenting things, of course, I'm going to be watching comments in chat so that we can, discuss any questions or thoughts or ideas. Because if it was just about me yammering on without addressing you guys or talking to you guys. This would be a video and not a live, and I do want to hear from you guys. Okie dokie artichoke. So let's get started. So the first thing we're going to watch is Sarah Boone's hearing today. This was the first time that her attorney made an appearance. He is new after being retained on August 30th, officially. And he did use the word retained. And that is very important because there's a big, huge distinction there. And we're going to talk about that. But the first thing I want to show you is this is Sarah. We'll call this before. This is how she entered the courtroom. She looks over at her lawyer. She's clearly all smiles. And we're just going to call this the before. This is Mr. Cacciatore. We're going to hear a little bit from her defense attorney because he does say some interesting things at this hearing. And if you missed it today, I want you guys to be able to catch up. And also, it's good to hear it a couple of times, frankly, because sometimes the first time you're missing things. So here we go. Hold on. I want to get him when he first comes up to the podium. All right, here we go.
And for two other motions for the appointment of a forensic.
Hold on a second. Let's go back here. I got a little too hasty.
Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her.
Okay, so Dr. Julie Harper, sexy wild thing, McLovin, freaking babyface claws, member for 12 months, bruh. So honored to be a part of your channel in this beautiful community. Thank you so much. I'm honored to have you. And thank you for being a member for 12 months. You guys' support means everything to me. Oh no, Bo Peep, we're going to take this as it comes. We're going to hear it just how it was said, because it's important. And as you can hear, as you're hearing here, he's talking about a psychologist that was already retained, hired, retained, appointed, selected by Sarah's original trial attorney, Mr. Padilla. And he is correct in saying that Ms. Harper has met with Sarah Boone many times at the jail. And so I see also, though, I wanted to highlight this comment too. So Cement Shoe said, I heard the judge might be replaced because of a conflict of interest, something to do with Sarah's brother. Interesting. I would think that would have come up already. I'm kind of curious about that. I'll see what I can dig up and find, because I feel like Judge Kranick, let me see, when did he get on the case? Give me just 1 second here. Okay. He has been on this case since the first, let's see, January 16th, 2024. That's where the pretrial conference has been scheduled with in his courtroom. I'm sure he was appointed prior to that. The last entry for hearings, I'm looking at the hearings now on the county clerk's website. And the last hearing that was heard in front of Judge Wooten was the trial that was scheduled for October 30th, 2023. So he has been on this case for quite some time, and I feel like Ms. Cashman would have caught that, particularly because there was an issue came up with regard to bail. And Sarah was alleging that Ms. Cashman lied to her brother, remember, as far as, who could sign for her bail or whatever. There was some issue there. I feel like Cashman would have caught that already, but I'll look into it. And Tracy says, doesn't she have a brother in jail, Jen, or did? Yes. She either has one currently or he was at one point. So it is what it is. I don't know, and I'll look into that. I don't have the answer for that. I've not heard that yet. And so but I definitely will look into that for you guys. Okay. And the thing about what I find interesting about what Mr. Owens is attempting to do here is while he's simultaneously asking for more time, okay, and he's not asking for 3 weeks, he's asking for 3 months. What he really, ideally, he would be ready for trial by the end of the year or the beginning of 2025, which makes it, 3 or 4 months, actually, really. And he says that it's because he needs time for, expert witnesses to come in and speak with Sarah, and there's a trust level there, and there needs to be trust established, blah, blah, blah. But at the same time, he wants to use one of the psychologists who's already evaluated Sarah. And that didn't make sense to me. If somebody will put, I can look up if her brother was in Orange County, then I should be able to find his case and find out who the trial judge was, and if it was Michael Kranek. I don't know if it was or not. So if you know the brother's name, because I'm given to understand that he has a different last name. Tyler Paulson in Orange County. I'll look it up. While I play this for you guys. Give me just a second. Here we go.
A couple of times last week, I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again? I'm sorry.
Michael Berkland. I followed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I approach them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the
Morning, sir.
Okay. So I went on the Orange County Clerk's website and I looked up Tyler Paulson. There's only one record for Tyler Paulson, and he appears to be from Winter Park, or it happened in Winter Park anyway. And the charge is operating a motor vehicle mobile home with expired tag. And that's it. And that happened back in 2021. So if there's anything before that, it's not available on the Orange County, or it's possible that whatever it was that he may have done was not in Orange County. So let me see if I can find out anything more about that. I just think that if her brother came in contact in any way, yeah, maybe it's the other brother. But I will say this. I feel like if her brother had come into contact in any way with the judge, I don't know that that would necessarily be a reason for the judge to recuse himself. And here's why. Because in the case against, out of Ohio, with the Wagners, the same judge presided over all of it. And Billy Wagner, the father, has his trials coming up soon too. And he presided over all of those, although they weren't tried together. They were all, well, Jake took a plea or pled. His mother took a plea. George Wagner went to trial, was found guilty, and Billy Wagner, the father, is scheduled for trial either at the end of this year or the beginning of next year. I have to go check on that. But anyway, the same judge presided over all of it, all the pretrial, then over George's hearing. He's going to preside over Billy's hearing. So I don't think that the judge but I'm not sure because I'm not an attorney. So take that with like a dumpster truck amount of salt. Okay, Kara says, thank you for the super chat, by the way. It's John Tyler Paulson. Okay, I will look it up. Okay, I will look it up. And I'll keep playing this while I look it up. Okay, here we go.
Thank you. The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars, the columns count 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't. They were all filed yesterday, 19.
No, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Brooklyn 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Brooklyn. I believe he has the autopsy.
All right, I found it. Okay, so John Tyler Paulson. Let's see. The judge that worked on the case was not Michael Kranick. The judge was Jennifer Harris. This happened 8/15 of 2023. This is his latest situation. He's got 1 charge of dealing in stolen property trafficking. The second charge is receiving money from pawnbroker by false verification of ownership or identification less than $300. And he has a petty theft charge. That is what I found. It's been Judge Harris the whole time. Let me just check and make sure. Yeah. So it doesn't appear to me from this one, and that's his latest one. Let me see if there are any other ones, because it doesn't do it. Let's see. I'll keep playing because I don't want to pull up somebody's record and show it if it's not him. So let me just do some digging around. We'll keep going, but there's another one I need to look at. Hold on.
We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Sure.
Office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one.
Okay, so it appears that there is truth to this situation with Michael Kranick. Okay, so the case against him, against John Tyler Paulson, who that Judge Michael Kranick presided over, happened in 2011. And it is interference with custody, showing obscene minor material to a minor, sheltered, unmarried minor without notice of parental or cause. And there's another charge, cause child to commit act of delinquent, and CR resisting officer without arrest. The other things that he has that Judge Kranick did not preside over are related to not registering as an SO. This was back in 2011. Let me see. Well, I'm not going to read his, but yeah, that was a long time ago. I don't know. I think it should be okay. Honestly, I don't know, but maybe not. Maybe not. So, but yeah, there you go. That's the deal. Thank you for bringing that to my attention, and thank you to you guys in chat for helping me find his record by giving me, his name and everything. I don't think that it's going to be a conflict like that. I feel like at the end of the day, these are two completely separate types of cases, number one. Number two, I think that it's so long ago. I mean, 2011 is a long time ago. Please don't make me do the math. I don't have it in me to do it. So that's what's going on. Okay, so basically, he's wanting to get more. The lawyer is asking for more discovery. This is discovery that Sarah Boone doesn't have. This is, I guess, videos. Like there's some surveillance video. Anyway, they're making arrangements, yada, 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 whatever, as Letitia says. Okay, so we're going to skip forward a little bit and listen to Judge Kranick's ruling, and then we'll look over at Sarah Boone's face, and we'll call that the after. Let's see what's going on here.
Just the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the palpable abuse of discretion when the court does not grant it. But it is critical to our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years.
Objection. I'd like to object. Listen, I'm going to try to keep it light tonight. Beach Lover, I saw your comment, babe. You know, I'm thinking of you. If you need anything, reach out. My email's always open. We're going to try to get your mind off of it. Here's my objection. He's talking about the need for these these expert witnesses. Okay, I get it. He does need expert witnesses, but you're talking about one of the expert witnesses already has a rapport with Sarah Boone. You've already said that she interviewed Sarah Boone at least 6 times, and we're going to check the visitation logs, and we're going to count exactly how many times she did visit with her and for how long. So it's the rapport should be established. Come on, man. Come on, man. All right, I'll be right back. I got to take care of the dog. Give me a second. We'll let this play.
I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the two forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me,
Okay.
my predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew the last one. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim to. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 maker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No,
All right, thank you very much. All right, Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you've met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order and a judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment,
We're going to call this face during, okay? After this, I went and did some Googling in between when I left you guys this morning and now, so that I could better understand the battered spouse defense and the criteria of it. And so we're going to talk about that as well. But let me highlight a couple of member milestones, please, just really quickly. Tess Max says, who's been here for 16 months? Thank you, babe. Thank you so much for doing all this extra work and researching everything Boone for us, Jen Lou. Plus, you do it with wisdom and wit. Love you. Love you too, Tess. Thank you so much, babe. And Beach Lover says, who's been a member for 4 months. Love your channel and chat, friends. Yay. Good, Beach Lover. We love you too. And thank you for being a member for 4 months. I appreciate the support very, very much. Couldn't do it without you guys. Faux show. I'm going to rewind it back just a little bit, because to be quite honest with you, this part of when the judge is giving his decision is done in such a way, it's like a church read. It's where you read somebody for absolute filth, yet you never use a single solitary profane word. There's no profanity, there's no cussing, and he just does it so well. And to answer Natasha, no, Nestor is my chocolate lab. He's 16 and he's having some struggles, so I gotta stop every once in a while and take care of him, but he should be good for a little while. So let me rewind just a scooch, and let's play it and see what Miss. I know this is wrong of me, but I can't get past Sarah's face. Like, she knows. All right, here we go.
The order and a judge portion, that trial specially set for October 7th, 2024, and that would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, This matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311 Southern 3rd 185 and 10.189, Florida 2nd DCA 2020, your motion for continuance is denied. This trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m. Investigations by and through
I'm muted. And we'll call this the afterface. So basically, as you heard, the judge said no. And this is why I like Judge Kranick, because he came with receipts. He was fully prepared to say, listen, bruh, you weren't appointed this case. You took this case on, and by your own choice. And so you knew what I wrote in the order. You cited the order in your motion for continuance. And so the answer is no, which I can't say that I'm surprised. I thought that he might extend it out 30 days, making the trial November instead of October, but he didn't. But I think one of the reasons I think he didn't do it is because Sarah Boone does not have a good history with her attorneys. Okay. I think that is like the understatement of the year, maybe even ongoing 5 years, as Sarah Boone says. And I think that this does not give Sarah much time, or Mr. Owens much time, for a conflict to arise such that would necessitate a motion to withdraw. And this is basically what Judge Kranick said.
Ain't nobody got time for that.
We don't have time for that. We're going to trial October 7th. The end. Period. That's it. And Sarah's big mad. All right. Now, this battered spouse syndrome. Interestingly enough, I have something for you. And the reason I picked, of all the things that I could have picked to read, although this is an older article, it as specifically is about Sarah Boone, and it's quite apropos. And so I thought, what better way to explain battered spouse defense than to read you guys an article that specifically talks about Sarah Boone. Hey, Allie, good to see you, babe. All right, here we go. Defendant relies on battered spouse defense in upcoming murder trial. This is the Pumphrey Law criminal defense. As the murder trial approaches for defendant Sarah Boone, her defense attorneys have stated that their client will be using the battered spouse syndrome as a defense to her boyfriend's death in 2020. This article will provide details regarding the case, along with relevant information on battered spouse syndrome, charges for domestic violence, and example case. I also would like to point out that whenever you Google battered spouse syndrome, Google is very helpful and gives you all kinds of resources before it actually answers your question. And so I just want to remind everybody that if you or someone you know needs help, there are plenty of resources available. And if you need help getting those resources, email me at blindjustice@gmail.com, and I can I can send you those resources. Okay. Free of charge from the resources. That's what I'm trying to say. Like, that's what I mean. Like, these are toll-free numbers, toll-free hotlines, help that's for free. I'm not talking anything about me. It just came out kind of weird, and I wanted to make sure that was clear, because nobody should be in an abusive relationship. All right. Just what is battered spouse syndrome? This is a trigger warning. Despite some belief, battered spouse syndrome is a form of post-traumatic stress disorder, PTSD, rather than a mental illness. Battered spouse syndrome, or previously referred to as battered women's syndrome, is a condition that is created by sustained physical, emotional, or SA from a partner that results in a variety of physical and emotional symptoms. Battered spouse syndrome is often the result of repeated violence, such as beating, choking, SA, verbal abuse. Common symptoms of battered spouse syndrome are physical indicators of physical violence, which can include black eye, bruises, broken bones, cuts, scratches, choking marks. A person accused of killing their spouse out of fear may suffer from battered spouse syndrome, which is created after a cycle of abuse within a couple's relationship. According to the Florida Bar, there are typically 3 phases in a cycle of abuse. Phase 1, verbal abuse, minor battery incidents, attempts from the victim to placate the abuser. Phase 2, acute battery incident, in which spouse was severely beaten or abused. Phase 3, displays of regretful and loving behavior to reinforce the victim's hope for their spouse's reform. The cycle is often an ongoing one, with phase 3 rotating back to phase 1 after a period of time. In these instances, the victim of abuse may feel completely helpless. Some may feel as if they have no option but to kill their abuser as a means of escape. According to NSU, there are 4 general characteristics of battered spouse syndrome. 1, the spouse believes the violence was their own fault. 2, the spouse is incapable of placing the responsibility for the violence elsewhere. 3, the spouse fears for his or her life and or their children's lives. And 4, the spouse has the irrational belief that their abuser is all-knowing and at no fault. In a criminal case where a victim is accused of killing their spouse/abuser, it is important to mention that battered spouse women syndrome is not always recognized as a defense. That is because proving a spouse was abused does not necessarily imply, Sarah, pay attention, that they will be acquitted of a criminal offense. Instead, the introduction of the battered spouse syndrome can be used as evidence for other reasons of defense, such as self-defense. The use of battered spouse syndrome can give credibility to the defendant by proving he or she believed that they had no choice but to defend themselves from great bodily harm or imminent death. Case details. Orange County Police arrested Sarah Boone, 45, for the 2020 death of her boyfriend, 42-year-old Jorge Torres Jr., after he died inside a suitcase in their home. According to the report, the incident took place February 23rd, 2020, in their Goldenrod area apartment. Let me check on you guys and see how you're all doing. Okay. Guys look like you're doing okay. All right, here we go. Let's keep reading. During the investigation, Boone told police the couple had been drinking wine and playing a game of hide and seek. After becoming too tired, Boone claimed to have gone to bed and passed out. The defendant woke up several hours later after hearing her phone ringing. Torres's body was found zipped inside a suitcase where he was unresponsive and not breathing. Boone contacted the police, who pronounced him dead on arrival. Upon further inspection, detectives found videos on her phone that showed differently. The videos show Torres trapped inside a suitcase on the couple's living room floor. Torres was heard repeatedly calling out to Boone. In several instances, Torres told Boone that he couldn't breathe. Quote, "Yeah, that's what you do when you choke me," Boone responded in the video. The rest of the video shows George struggling to get out of the suitcase. Boone is heard telling her boyfriend that he deserved to suffer for everything you've done to me. During the pretrial hearing on January 17, 2023, Boone's defense attorney told the judge that the case was not yet ready. He stated that it was necessary to meet with the defendant and find defense experts for the trial. Boone's defense attorney has also stated that he plans to apply the battered spouse syndrome defense to the case. All right, so this is a case where a battered spouse defense was used. Wyand versus State. In 1994, is that Wyland? No, it's Wyand. In 1994, Kathleen Wyand was accused of shooting her husband, which resulted in his death. Before this case, Florida followed the minority rule that the victim has the duty to retreat before choosing to defend themselves with deadly force. The gray area in the case was, what if both the defendant and victim resided in the same home where the killing took place? A forensic psychologist expert witness was able to prove that Wayand showed all signs of battered spouse syndrome. The expert also stated that it was clear that Wayand believed her husband was going to kill her. However, the jury concluded that, quote, the fact that the defendant was wrongfully attacked cannot justify her use of force likely to cause death or great bodily harm if, by retreating, she could have avoided the need to use that force. Wayand was convicted of second-degree murder of her husband and sentenced to 18 years in prison. However, the case did open a discussion regarding battered spouse syndrome as a defense. Okay? So these are some of, the charges that you would get if you were the perpetrator of domestic violence. Now, let me stop sharing this because now I just want to talk to you guys for a second. So let's think about what we just read there, what I just read. Yes, Trish. Trish asks, will there be cameras allowed in the courtroom for the trial? Yes, they will. We will be able to watch, and your girl will be streaming the trial, which is I'm doing because at great sacrifice, because it's a Florida courtroom, which means where I live, and it means that there will be no naps for your girl. I'm giving up my naps in order to stream the trial all day, every day from start to finish. So you're welcome. So yeah. Okay. I've been following Sarah Boone's case for years now. And at this point, there is literally, there's nothing that would keep me from watching this trial. Nothing. I would stream it even if I had one person watching, and that one person was me. Okay. So let's talk about this whole situation with battered spouse syndrome. Let's look at this. Let's talk about it. We do have history of domestic violence that exists between George and Sarah. And we have history where sometimes George was the perpetrator, sometimes Sarah was the perpetrator. But also, I think one of the issues is a power dynamic that exists. And one thing that's missing from all of this is this imminent fear. Okay. Sarah has many times described that we were having a good day. Today was a good day. She went full Ice Cube. Today was a good day on us. Several times in the interrogation, she mentioned, that it was basically like day camp with wine. They were doing arts and crafts. They were doing puzzles. They were drinking wine. They were playing hide and go seek. It was, so where was the imminent danger? Where was the imminent threat? In fact, the investigators, the detectives, asked Sarah many times if there was an argument that day, if there was a fight that day, and she said unequivocally no. In fact, not only did she say no, she said she got defensive about it, and she continued to repeat that it was a good day. Could it be argued that that is maybe a sign of she believes that her abuser, in this case, if this is what she's using, if she's using the battered spouse defense, and in this scenario, George would be the abuser, and that, he's all knowing and all powerful and faultless and doesn't do any wrong. I suppose, however, she isn't actually talking about George. She's talking about herself in that interview the majority of the time, that she has done everything in the world to help George. She has, gotten a hold of his probation officer and made sure that he's on track with his probation. And, she's given him a place to live, and she's been supportive, and when he lost his job and all of the things, she's actually building herself up. She doesn't actually talk positively all that much about George. And I would submit that if anybody might have a case of battered spouse syndrome in this scenario, that it might actually be George and not Sarah. If you really look at the circumstances, it's Sarah's apartment. Sarah is the one that's on the lease. Sarah is the one that had the phone. George didn't even have his own cell phone. He had to use Sarah's. And Sarah had an iPhone that she didn't just use the number lock code. No. She used facial recognition. So if George wanted to use the phone, he always had to ask. It's not like he could use the phone without Sarah knowing about it. She would know every single time he would need to use the phone because her face is required to unlock the phone. And I think that dynamic is potentially what negates this battered spouse defense. And I think after thinking about it all afternoon and this evening, what I really think is when Padilla and Bankowitz brought in expert witnesses, psychologists, to evaluate Sarah for battered spouse syndrome, I think that they found that there wasn't any. And I think that that might be at the crux of the issue of the conflict between Sarah and her attorneys. I think that they might have said to the attorneys, look, it's clear that this was a toxic relationship, but I'm not so sure that Sarah falls under the category of suffering from battered spouse syndrome. And I think that might have been the issue. And to that point, the next thing I'd like to show you guys is this. Oh, hold on. It's not going to do any good for me to show you this if I don't share my screen and add it to the stream. So let me start there. I've got like 11 billion tabs open. And so let me close a couple of these that I'm not using any longer. Okay. So shout out to my girl B Crumbs. She is the one who requested these logs and got them for me and got them for me to share with you guys. She didn't get them for me. She got them and allowed me to share them. These are the professional visit logs, okay? And you can see here, Harper, Julie, visit 8:58:20 to 13:44:21. So that's almost 9 o'clock to almost 2 o'clock. 10, 11, 12, 1, 2. That's a 5-hour visit, okay? If you're keeping track. All the way back on 8/21 of 2020. That's when her visits first began, okay? Oh, look, there's Billy Lane. He's been on this case for quite some time. Harper Julie, 8/4/2021, 9:44 a.m. to 11:54. So almost a couple hours there. Okay, that's number 2 visit. So we have one visit that is 4 hours and then another 2 hours. So we're up to 7 hours now. Okay, 6 hours. We'll lowball it, 6 hours. Okay. Second visit and now we're up to 6 hours of evaluation. Another visit with Harper Julie on 3/10/2022 from just say 2:30 to 4:30. It's another 2 hours. So we're at what? 9 hours now and 3 visits. I think that's it. I'm going to make sure. Oh, wait, hold on. Hold on, let me count these again. So we have her here. Oh, you know what I'll do? I'll just do it this way. What? For rails, that won't work. All right, here's 1. 2. 3. 4. 4 times. And the last time that she met with her was March 10th, 2022. So it's been a couple of years. But what do you imagine in those 2 years changed significantly? What information could Sarah have that would, about her life, about their relationship, that would change her initial evaluation so significantly that she would need 3 more months to evaluate her. You know what I mean? And to build rapport. I don't think there is any. And I think that Judge Cranick, I think I would have compromised and given him a month, but that's all. So at the end of the day, you can see that she met with her several times and for several hours. And I don't think that anything has changed in her circumstances that would change, that would require any longer. I think she could meet with Sarah for a couple of hours and call it good. Hell, even 4 hours one time and call it good, because she's already built rapport with her. She's already looked over the, she's already has notes and stuff with her. She can reopen her files. She has a file on Sarah. So I don't think that it's necessary for him to have an additional, 2, 3 months, 4 months to prepare for trial. I think that's poppycock. And I think that Judge Cranick ruled correctly. And thank you, Casey May, for being a member for 9 months. I appreciate that, babe. Thank you very much. So yeah, I don't see the big deal. Just don't. So Carolina Hurtado says, can James Owens use George Torres Jr.'s brother's arrest records? They all have DV charges except for Juan Torres. I'm just curious if a defense attorney can refer to family members' records. No, which is why he did it in the court of public opinion. Okay. See, this is where knowing how to utilize the media as an attorney comes into play. That type of evidence that there is a familial history on George Torres' side of domestic violence is not admissible, because George is not on trial, Sarah is. And even if she were using the battered spouse syndrome, it would be limited to the things that George did, not any of his family, unless they participated in it, right? Unless they were part of it, which they were not, or there's no evidence of that. And I don't think that they were either. So we have that. Now, that's why he said what he said in front of the in front of the courthouse today, because quite frankly, what he's saying is, hey, George is not that great of a guy. And, it runs in his family, and look what his brother has done. And his brother did this, and, he's being accused of murder right now. It happened back in May of this year, 2024. These are bad, this is, a familial history. And the reason that he's doing that is because Sarah has, by her own behavior, really made an impression on the public. And at the end of the day, it really doesn't matter what the public thinks, because even if somebody that is called for jury duty has heard that interview that he gave out on those steps, they can still be picked and put on a jury, because all they have to do is agree that they are going to base their verdict and decision solely on what's presented in the courtroom. And frankly, that interview isn't something that's going to be presented in the courtroom. So they're not going to, you can hear it and not use it as part of your deliberation. That's what, you agree to as a jury. It's just dirty pool. And we're going to talk about a plea. Ro, give me just 1 second. So it's just dirty pool. And to that end, I want you guys to hear the interview with the lawyer afterwards. Now, I know that I said that I would screen record this. Life a little bit got in the way, and I'm sorry, and I didn't have time to do it. But the audio is good, so I think we should be okay. All right, hold on just a second. Oh crap, I didn't mean that. I have to I have to add it to the stream. Give me just a second. Sorry about that. Now, you guys to brace yourselves, because some of the things that are said by the attorney about George did make me angry, and we're going to talk about that, and we're going to talk about all the things that he said. So here we go.
7 p.m. only on Fox Local.
Let me make it big for you guys.
So why
Thank
this
you.
case?
Excuse me?
Why this case?
Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration. Okay, this just a gap in the system that hardly ever happens. On the federal level, on the state level, everybody charged with a crime is entitled to counsel. Okay, everybody, never unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling. But that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime.
Okay, first of all, he says somehow. Sir, and I might have to roast him just a little bit, because this is nighttime, and I've had an opportunity to hear what he said. This is the second time that I've watched this, and now I am feeling some type of way. And let me just say this, okay, sir, somehow, as if it's a mystery. Now, as a lawyer who practices in the state of Florida, that Florida has some of the easiest FOIA requests of all time. but more specifically this case, which I'm sure you did your due diligence, right? And you know that you can go right on over to the Orange County Clerk's website and you can type Sarah Boone into the search. Once you pass the CAPTCHA 2 times if you're Jen Lu, then you are free to look at all of the things that have been submitted to the court, including her letters, which in this last letter that she wrote included her advertisement. So please stop. Don't play games, sir. That's how it got there. You know how it got there. I know how it got there. 142 people in my chat know how it got there. And we don't appreciate you trying to act like it's, somebody did something untoward and now Sarah's, whole life is online. Stop it. Ridiculous. Here we go.
I saw it. I didn't immediately act on it. I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen. I had another case down here in Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that. And she had a third party, a girl from Minnesota, that reached out to me, I think first just to see if I was legitimate. They said to see if I think catfishing is what they thought I was doing somehow.
Okay, so remember when we were reading the jail file that was uploaded to the court? And in that jail file, it talked about an attorney that came to see Sarah Boone. I'm going to let this play and I'm going to see, I'm going to pull that up for us to look at. Okay. Just to refresh our memory. So I told y'all we were going to do a deep dive. I told you I was going to present evidence and that's exactly what I'm going to do. All right, here we go.
Some fraud. I think once the third party realized that I was genuine, then Sarah called me and we talked on the phone a couple of times. And I said, hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th. And I spent about 4 hours with Sarah Boone at the Orange County Jail. During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed the notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it. So there were attempts to settle it. I was kind of like a mediator. I was kind of like a go-between because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it. But after those, so I met with her that day. I went over to Tampa, handled my case. I think I was done at 2:30. I came back. Well, Billy Lame, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with them. So the three of us met. This was, I think, the 21st, like it's set from 7 to 8:30. We met for about an hour and a half. And, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8:30. I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home and Sarah called and we talked again. Of course, I was still thinking about it, what to do. And but I told Sarah I was not committed to doing it.
All right. So I'm as I'm listening to this, it's I'm trying to put the timeline in order. Here is when I think that this happened. Okay. This is the only thing that makes sense in the record based on what he is saying. So can y'all see this? Okay, good. All right. Let's see. Let me make this bigger for my old eyes. All right. Let's see. 8/7/2024, 8:22 p.m. This is when the report happened, but I'm not. It says Sarah Boone was called out for an attorney visit in FDC B dorm. Inmate Boone stated, "No, I don't have an attorney. I had too many random people coming to see because of my case. I took the paperwork from the attorney and delivered the paperwork to inmate Boone." Inmate Boone was advised at approximately 21:59 hours that she had an attorney visit. Inmate Boone requested to know who the attorney was, being that she has no attorney assigned to her. Inmate Boone stated that she does not feel comfortable visiting anyone that she doesn't know because crazy people have been reaching out and scheduling visits with her, claiming to be someone that they are not. Inmate Boone was notified that the attorney's, this is a different attorney, was James, was that, so there's, okay, hold on a minute. My bad, I should have read this a little further. Let's go back to the interview.
That was on like the 23rd. Within that third.
All right,
call,
there's more ones to find, so hold on.
Really nice.
I'll find
that I really respect. We developed a relationship, and she asked me if I would go one more time. So I flew back down. We met again a couple of times. I can't remember the dates now, 25th and the 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And on both sides, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But, I like her. She likes me. We communicate well. I think we're both on the same page. And, I spoke to my family, my wife, my daughter Sarah about it. Sarah's thinking about law school, so I got their blessing. I have, some colleagues that I practice law with, a law group there in Milton. And obviously it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help from the staff, but we're trying to assemble a team right now. I've got a couple of friends that are lawyers that have indicated they're going to help me. And what are friends for?
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
Who's paying for it?
Sarah owes me. Sarah owes me.
Can you speak a little more to your plan for defense?
Okay. I'm looking through the jail report, and for whatever reason, his visits aren't mentioned. And I don't know if that's because they went smoothly, or if the reference to him visiting has to do with the staples and the paper clips being in there. Now, this is what I want to address, is this retained versus pro bono, okay? And he made it very, very clear that he has been retained. And, so Kara says could be under attorney-client privilege. The substance of the visit would be under attorney-client privilege. However, they do keep a record the jail does of the professional visits that inmates have. And so I think that when we read that jail report and they were talking about she had been given paperwork and there were staples, paper clips, stuff like that, and how they had to go through it and search it, I think that is the stuff that he gave to her. So they would keep a record of the visit, just a note that there was a visit and who it was and how long they were there, but they're not allowed to, like, you can't record it or anything like that. Those are privileged conversations. So, okay, on to this pro bono versus a retainer. Obviously, pro bono means he did it, you're doing it at no charge. But he's saying that Sarah owes him. He was retained. Well, sir, Sarah has been sitting in jail since the time of her arrest. So 4 years and 6 months, almost 5 years. She's been sitting in jail, awaiting trial. How is she going to pay you? With what funds? This isn't like a situation where this is a civil suit and he's taken on this case based on contingency, meaning that he's agreed to represent Sarah, and whatever settlement she gets, he will get a cut of, and that's how she will pay him. That's not this. So what did she pay him with? Is she going to pay him in honey buns and ramen? I don't understand this. It makes no sense to me. And I'm quite confused by this, and him saying Sarah owes me. So what does that mean? Well, does that mean that because he represents her, he is going to negotiate interviews, a book, her life rights, some kind of something that has some sort of monetary value? Because right now, he's going to be collecting in, like I said, honey buns and ramen at this point. That's what I'm wondering. I'm wondering if this has to do with some type of life rights situation, if it has to do with some type of, the selling of her story, as it were. I'm not sure. And this is giving him free publicity, but I mean, ideally you'd want to be paid. Publicity is great and everything, but I don't know. Something about this does not feel quite right. I can't quite put my finger on it, but something about this feels wrong. Let's listen to what he has to say. Oh, wait, I lied. There was something else I wanted to address. This notion that he went, or not notion, because it's not a notion. He said that he went and spoke to, he was like a mediator between Sarah and the state as far as the plea deal goes. And what did I tell you guys? I mean, listen, there can still be a plea deal worked out up until the day of the jury is, the jury summonses go out, the jury pool shows up, and they can go in front of the judge at 9:00 that morning on October 7th and say, Your Honor, we've reached a plea deal. We've reached a deal. It happened with Aiden Fucci. The day of court, or the day that the trial jury selection was set to begin, Aiden Fucci pled. So it can happen. There's no guarantee that until the trial starts, there's no guarantee of a trial. So that could happen. I don't think that Sarah is going to be happy with, I think what Sarah's hoping to get is her charges substantially reduced, and that she maybe only does another 5 years, so 10 years total. I think that's what she's looking for, And the fact of the matter is, I don't think that the state is willing to negotiate that way. They don't have a reason to at this point. If it goes to trial, there is, they can bring up all the expert witnesses that they want on the defense's side, but we are regular people, and the jury is going to be comprised of regular people. And we have even an advantage over the jury in that we're people that follow true crime on a regular basis. So, put yourself in the jury's shoes. All right. You hear all of the evidence, you hear the medical examiner testify, all of the things. And then they show you those 2 videos. How do you get around that? I just don't see how, I really don't. And I have tried in every which way to figure out some type of loophole, a potential loophole that somebody on the jury could see and see that as something other than what it is, which is a man in a suitcase telling Sarah that he can't breathe, asking her to let him out, and she's taunting him. I just, y'all still on that dadgum debacle of a romantic dinner that Juicy Rose cooked for old Can, cold spaghetti, because you know how he kept blowing on it. You know what he was doing? He's buying time. There was no steam coming off that plate, y'all. That man was buying time. He did not want to put that disgusting meal in his mouth. And I don't blame him. So I've never seen meatballs that are gray. That should be like a huge red flag. The little smokies, I don't even know why you would put that in there. But how do you simultaneously have dry pasta, like there's no sauce, but also the noodles are incredibly mushy? Like, how does one even accomplish that? I don't even know how you do that. And okay. And the other thing is, little smokies are already cooked. Okay. All you're really doing is heating them up. And she went on this long ass, how I met your dad story, right? Complete with their first prison visit where they also had their first kiss, and she got emotional. And all the while, the spaghetti and shit is still on the stove. You know that those little smokies were just shriveled up to nothing by the time Ken got home. Oh my God. Oh God. Kelly P says, Chen Lu, can you imagine the attorney pulling out exculpatory evidence and jury finds her not guilty and Sarah sues the state? Well, okay. The first part, I mean, anything's possible, but is it probable? No. But even if that were to happen, Sarah cannot sue the state, because there's no Brady violation if the attorney finds it, because it's going to be in her discovery, right? And the only way that you would be allowed to sue the state is if you were tried and convicted and you were actually innocent. Then you can sue. You can't sue if you're sitting in jail awaiting trial. You go to trial and you're acquitted. You don't get to sue. And I really don't think that I don't think that's going to happen. So, all right, let's hear what the rest of what this attorney has to say, and then we're going to talk about the stuff that he filed today and some other things, and then I'll let you guys go.
Well, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think y'all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The two experts that I had asked for, well, there's a third one, but two of them are from my area. Dr. Harper's from Okaloosa County and Dr. Berkman's from Escambia County. But I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so then if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense. And then we go from there. That's really all I can say. It's up to Dr. Harper, not me.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations. I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt.
I mean, he's not wrong. This burden is on the state. It's not on him. But Lil Red says, I really thought I heard judges pro bono. He did say that. The judge did say that you're taking it on pro bono. But in this interview, he didn't correct the judge. He cleared it up for the judge because it doesn't, at the end of the day, whether he's doing it pro bono or he was retained, right? Sarah has been declared indigent. So he can request that the JAC pay for defense experts. But what he cannot do is ask the JAC to reimburse him for his time. And that's what the deal is here. So I guess that's why he didn't correct the judge or whatever. I don't know. I really don't. I don't know what Homeboy was thinking. Like this is, I mean, Sarah does have the right to have counsel. What she doesn't have any longer is the right to the public defender. Okay. So let's make that very clear. The judge did not make her not have an attorney. Okay. He just took away her ability to use the public defender's office. And the fact of the matter is, this should have gone to trial a long time ago. Okay. We should not be almost 5 years for her because of attorneys. Honestly, this should have, at most, I'll give her 3 years at most. Okay. That's, Sarah and Letitia Stout got arrested around the same time. I think actually Sarah Boone was arrested before Letitia was, because Letitia was arrested in March. And Letitia has already had a whole ass trial. And she's in prison, and she's suing the prison in the same amount of time. Sarah got arrested and charged before Letitia Stout. Letitia played all kinds of games pre-trial, went pro se, then ended up not, changed her plea from not guilty to not guilty by reason of insanity, which creates its own issues and evaluations and all the things. And that heffalump has already been to trial, been convicted, gone to prison in Colorado, been moved from Colorado to Kansas, and is suing the Kansas prison. And Boone hasn't even gone to trial yet. This is ridiculous.
That's all I really want to say. Just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens at the end of this week. It'll be it'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres's prior arrest. I did want to say something else, but
Yeah, we know you want to say something else. And I'm going to tell y'all right now, if you didn't see this today already, what he says is highly offensive. Okay. And I don't just want you guys to brace yourselves, but before you brace yourselves for something offensive, let's take a moment. Let me take a moment to thank Bodine for the $10. I appreciate that so much. Love your deep dive into cases, such thought-provoking discussions. You're so smart. Thank you. I appreciate that. Very generous and very sweet. Thank you, Bodine. I appreciate the support. The thing is, and I would be interested in it to look into this. And I didn't even think about this when I was doing all the Googling and stuff today. And maybe I will do like a separate video for you guys and just put it up, because I'm really curious of the and I'm only going to be looking at Florida cases, because at the end of the day, it's a Florida case. So we want to, if we're going to do comparisons, right, the way to do it would be only in Florida. But what I'm really curious about is how many times in Florida has the battered spouse defense been used and the defendant has been arrested also for domestic violence? Because I'm I'm curious about that. So I wonder about that. Well, I'll have to look into that and make a video for you guys.
I want to say something, but I'll wait for you. If you
We
got
gotta
questions.
move downstairs.
Okay.
Or, I mean, we can just wrap it up.
They're done with
I
them.
want to say this. The Torres brothers are violent towards women. I'll say that again. The Torres brothers, George and Farrell Torres, are violent towards their women. Farrell Torres is George's brother. Are y'all aware of this? He was arrested in May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here. He called 911. Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction. I seriously doubt that's going to be admissible in my trial. But there's two sides to every story. And Sarah's got a story to tell. I think she's been mistreated to some degree. It's difficult to represent yourself. I wish you could just imagine if you had a daughter that was in her situation where she's representing herself, or maybe a sister. Just for 10 minutes, just think about her situation. You know, she's backed into a corner, and she's the type, like most of us are, they're going to come out swinging. That's what she's been doing. Some of it is probably appropriate. Some of it has been inappropriate, but it's all she knew to do was to fight. And she's been fighting. She doesn't have to fight anymore. I'm going to do the fighting for her. So she feels good about it. I feel good about it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying.
Thank you.
Thank you.
I'm cleaning up my yard.
Okay, so that hang on a minute. Let me look something up really quick. Hold on a minute, you guys. Since he decided that it would be a good idea to bring up George's cases and how violent George and his brother are to women, we're going to look it up. So give me just a second. actually, you know what? Hold on a minute. Let me do this a different way. Hold on. Sorry, you guys. Why did it do this? I wish it would let me look him up by Torres Jr. instead, because there's a lot of George Torreses. There's several pages worth. But I think his is on like page 3. Just give me 1 second to get to it really quickly. I think, let me just make sure that there aren't more from before 2018. That are for, anything related to there's 500 entries. Well, we're going to go back to page 3 where I know they're at. So the one from 2019, he has a violation of pretrial release conditions. That's that body cam footage we watched, right? So, but the original one is this one. Still the pretrial release. I don't know that we're going to be, I mean, I'm sure the state has them, but let's be honest. I don't think that, I don't think it's accurate for him to say that George and his brother have a history of being violent towards women, because let's be honest here. In fact, I'll tell you what, let's do this. Let's go right back over here to Orange County. Okay. And let's type in Sarah, and because she's been arrested more than once for DV against George. So let's just see what we can see. All right. All right, here's her one from 2018. This is the one that was closed. Now, this is from 2018, battery by strangulation, dating violence. Now, we know that the case was dropped. We know the case was not prosecuted, okay? It doesn't mean that it didn't happen. And, so if we're going to go down the route of, who has a history, the truth of the matter is, they both have a history. Lee, that's a really good question. Was she ever violent with her first husband? I can't find anything, any charges like that. I do know that Brian did say in his interview with the police in the car that Sarah was aggressive when she was drinking. But as far as charges, I am not aware of her being charged. And so we'll see. So, we'll see. I mean, that's okay. That's a really good question to ask. And let's think about this. He did say in his police interview that Sarah had a history of being violent towards him, and that he didn't call the cops on her. Okay, but in the situation between Sarah and George, while Sarah may have gone around and told a couple of people at the apartment complex, if you hear any noises, don't say anything, don't call the cops, mind your business, basically. But she's the one that actually called the cops. So it's I don't think that Sarah is going to meet the criteria for a battered spouse. I just don't. I don't think that there is a loophole to get the videos thrown out as evidence because they were used in the probable cause. They were used in the information. And that's what secured her. That's what got her the arrest warrant signed, and that's what got her the charges. It was used as evidence. So I don't think that she's going to be able to get the videotape or the videos thrown away. I mean, Sarah also told the cops that she did everything that people do when they get ready to go to sleep at night, but that she fell asleep on accident. So Sarah can, I'm not really moved by any of this claims that there's, evidence of abuse on her phone and they're not allowing her to have it. The fact of the matter is, they're not going to turn that phone on. The phone is downloaded through Cellbrite, which essentially is a capture of everything that's on that phone in that moment. So if there is evidence that exists via pictures, text, whatever it is on that phone, it's downloaded and it's in that Cellbrite report. Now, what can happen is this is interesting to me because this is not something that he talked about, right? As far as hiring anybody to be an expert witness, right? Because the state in the last hearing where Sarah was pro bono told Sarah, hey, there's this person that does phone extractions. He's been used by other people. And I know he's part of the JAC. And but Mr. Owens over here didn't talk about that. Now, don't you think if he really believed that evidence of the abuse existed on that phone and it's not in the Cellbrite report, and it's in fact being withheld from Sarah and by extension her attorney, wouldn't the first thing you would do would be to secure an expert witness to do their own download of the phone and analyzing of that data? That's what I would do if I believed it. But that's not where he's going. And Lil Red, many people have been overserved, sat down on the bed and woke up the next morning. Okay. But that's not what Sarah says she did. She said she went upstairs and got ready for bed, then got into the bed and fell asleep on accident. That's very different. Very different. And the thing of it is, Sarah is or was at the time an everyday drinker. We're not talking about she got too turned on the weekend and things got out of hand. Okay. We're talking about she drank all day, every day. So, and as far as any type of her trying to say that she was coerced or bamboozled or whatever to get, at the police station, she was read her Miranda rights and she made it very clear that she understood them. She was not intoxicated in that moment. And she pointed out that she is very smart and excels at everything. So I don't think that that's going to work. All right. So let's see these other motions that Sarah's new attorney has filed since this hearing. Let's see. Okay. The first one that he filed is, his name was was Dr. Birkland, by the way. I couldn't quite understand the audio, and you cannot rely on closed captioning because it gets wrong all the time. So basically, this is a motion to appoint a crime scene reconstructionist and death investigator. The defendant is charged with second-degree murder and has previously been found indigent. The undersigned attorney is privately retained and requests the assistance of a crime scene reconstructionist death investigator to assist in the defense. The defendant is financially unable to hire a due process provider, crime scene reconstructionist / death investigator to aid in the preparation of the defense and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. The defense requests the court appoint Dr. Michael Birkland, a crime scene reconstructionist death investigator for the defendant. Dr. Michael Birkland is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform his duties, including time spent traveling, and he's traveling from Barway. The undersigned requests Dr. Michael Birkland appointed a rate of $200 per hour for work and travel time with an initial cap of $6,000 exclusive of necessary costs allowed by state. And everybody that he's hiring or wanting to hire isn't local. So it's going to be, hold on. So it's going to be expensive for travel. I mean, all right. Here's the next one. This is a motion to appoint Julie Harper. Comes now the defendant, undersigned attorney, blah, 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 second-degree murder. Julie Harper, a forensic psychologist for the defendant. Dr. Harper is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform her duties, including time spent traveling. Excuse me. The undersigned requests Dr. Julie Harper be appointed. That's that. Let me see what else. Let's see. Additional discovery. All right. So this is the next one. On a showing of the state of attorney, the Office of the State Attorney to provide the written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular, the policy in place at the time of the interrogation of the defendant. So they want policies of the defendant. Now, the other thing that was filed, there was something else I wanted to show you guys because and I was just reading it. Not this. Give me just a second, you guys. There's another hearing coming up on the 24th for the attorney's fees for Mr. Hobson. Something else was filed, though, where they talked about I can't find it now. Shit. It's about her digital evidence. So Mr. Cacciatore made that available. So that's really kind of all I have. I think I was going to talk about what her attorney brought up with respect to George's brother, but upon further review and after hearing Mr. Owen's comments, I'm not going to, because oh yeah, it'll be televised, Bo Peep, because I think that by doing that, I think it would do exactly what Mr. Owens wanted to do, which is to get us talking about George's brother as if that has any bearing on this case at all, and it doesn't. And so if I do decide to talk about what happened in that case, because he hasn't gone to trial yet, he hasn't gone to trial yet. And even so, let's say I did decide to cover that case, right? I would not put it with this. If I did it, it would be separate. It would be separate. And I just think that what he was, I just think it was dirty pool what he was up to, and I don't appreciate it. No me gusta. And I am definitely going to have to take points off in the interview portion of the pageant for Mr. Owens for that, because I think it was gross. You know, I'm not saying what George's brother did wasn't violent, and if he did what he's been accused of doing, if he's, you know, it was horrible, it is violent, it is wrong, but this is not what, they're not the same thing. And George is the victim in this case and not on trial. And I think him trying to conflate the two is, you know, dirty pool, and I don't appreciate it. So I'm not going to play into his hands, because that's what he wants us to do. And I don't appreciate that. So I think that is really all I had. The context was, Harlot, that George and his brother are violent, have a history of being violent to women. That's what it was brought up in. That's the context it was brought up from. I don't know how to say that. That's the context in which he brought it up. That's how you say that. Sorry, I'm getting tired, you guys. Okay. So I think that that's pretty much all that I have for you guys tonight. I want to thank you all for being here, for supporting me. It means it means a lot to me. And I just appreciate it. I'm tired. And I hope you guys have a great rest of your Tuesday evening, what little is left of it. If you haven't done so, please give your girl a thumbs up. I appreciate it. The interaction helps get me and keep me in the algorithm. What else was I going to tell you guys? I will have a lunch with Lou tomorrow. I don't know what I'm going to be covering. It'll be a surprise to all of us. All right. Anyway, I'm going to play the outro. Thank you guys all for being here. Have a great rest of your night. And I will see you all tomorrow. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No militia.
Minutes later.
We all do a little mad sometimes.
And you know this, man!